The case of Bernstein vs. Skyviews and Amp. General Ltd, 1977, is a landmark High Court decision that significantly clarified the extent of a landowner's rights in the airspace above their property. It established the principle that a landowner's rights are not unlimited but are restricted to such height as is necessary for the ordinary use and enjoyment of the land. Hello and welcome to Landmark Case Laws Simplified. Buckle up as we explore the fascinating world of Bernstein vs. Skyviews Ltd together. The case arose from a dispute over aerial photography. The defendants, Skyviews and Amp. General Ltd, were a company that took aerial photographs of properties and offered them for sale to the owners. In August 1974, they took a single aerial photograph of Lord Bernstein's country home, Coppings Farm in Kent. Lord Bernstein objected strongly, claiming the photograph was taken without his consent and was a gross invasion of his privacy. He demanded that the negatives and prints be handed over or destroyed. The company's managing director later stated he would have complied if he had seen the letter, but it was unfortunately answered by an 18-year-old secretary who offered to sell Lord Bernstein the negative for £15. This led Lord Bernstein to commence legal proceedings. Lord Bernstein brought his claim in trespass, arguing that Skyviews had wrongfully entered the airspace above his property to take the photograph. He relied on the Old Latin maxim, quius est solum, eius est usque colum ad inferos, for whoever owns the soil, it is theirs up to the sky and down to the depths. The central legal question was whether this maxim meant a landowner's rights extended to an unlimited height, making any unauthorized overflight an act of trespass. The High Court, presided over by Griffiths J., ruled in favor of Skyviews, dismissing Lord Bernstein's claim. The legal principle established can be summarized as follows. A landowner's rights in the airspace above their land are restricted to such height as is necessary for the ordinary use and enjoyment of the land and the structures upon it. Above that height, they have no greater rights in the airspace than any other member of the public. The court's reasoning was based on several key points, rejecting the unlimited maxim. The court recognized that the ancient maxim was outdated and incompatible with contemporary society. Griffiths J. noted that if applied literally, it would lead to the absurdity of trespass being committed every time a satellite passed over a suburban garden. Balancing rights and public interest. The court sought to strike a balance between the rights of a landowner to enjoy their land and the rights of the general public to take advantage of all that science now offered in the use of airspace. It was deemed unreasonable and contrary to public interest to grant landowners rights over all airspace up to an infinite height, as this would severely restrict aviation and other activities. Lack of interference. The court noted that the aircraft flew at a height, around 631,000 feet, that did not interfere with the normal enjoyment of the land. There was no disturbance, nuisance, or damage caused. Photography not a trespass. The court held that there was no law against taking a photograph, and the taking of a photograph could not turn an act which was not trespass into trespass. Bernstein vs. Skyviews established the modern common law position on airspace rights in England and Wales, which has been followed in subsequent cases. It is a leading authority for the proposition that ownership of land does not extend indefinitely upwards. Importantly, Griffiths J. left the door open for future claims, stating that the judgment should not be understood as deciding that no successful action could ever be brought against aerial photographers. He suggested that if a person was subjected to the harassment of constant surveillance of his house from the air, accompanied by the photographing of his every activity, the courts would not regard such a monstrous invasion of his privacy as an actionable nuisance for which they would give relief. I hope this explanation of the case and its principle is helpful. Remember, your support makes all the difference. Thanks for being part of our journey.